So I'm sorry, you reserved.
Yes, I reserve close.
Okay. All right, Ms. Robinson.
Yes,
And let's please try to make it as brief as possible. And
yes, Your Honor, I will, I promise.
okay, thank you.
I will. May it please the court. There has been no evidence presented today that Mr. Hawkins has threatened to kill Ms. Stewart. The only evidence in which you heard was from her testimony herself. There was no evidence that he has showed up to her home unannounced, as she has stated. There's no evidence that he has cyber stalked her, that he has hacked into any of her technological information or devices. There only her words. There's been no evidence that he has ever harmed her, threatened her with his gun, even though she tells you that his words cause her to think that is a physical threat. But there has never been an instance in the past, iterated during divorce or after, in which she has stated that he has harmed her, has harmed their son, has threatened them with any type of physical violence or firearm, because it simply does not exist. The parties continue to communicate without issue via our family wizard in person after Miss Stewart had filed this petition for protective order on January 13th. You heard from both witnesses today how on January 22nd, the two exchanged their son after a visitation. The police weren't called. There was no third party there to serve as a buffer. None of that was necessary, because at no point of time during the parties' relationship or after divorce is finalized has Mr. Hawkins ever posed a risk, a harm, or any type of danger to Ms. Stewart or their son. And although she has testified today about how she's in fear of her safety, she hasn't supported that. They have not met their burden by the evidentiary standard to prove that Mr. Hawkins, that is a danger to their safety, that the only way to protect Ms. Stewart is for this court to enter an order. Now, she testified before you today how the security measure that she has in her home, she voluntarily decided to turn it off. She claimed that he shows up to her house unannounced and knocks on the door and stalks her. However, she presented no evidence of such. Instead, she stated to the exact opposite, that she turned this camera off so that even though she initially said she didn't turn the camera off, she tried to state that she turned the doorbell off, but she's not using the security measure in which she had installed in her home to keep her home and herself safe, because at no point of time has Mr. Hawkins been a risk to her safety. If she was in actual fear of her safety, she would have done each and everything possible to try to protect herself. She would have called the police officers. She would have gone to the police station. She would have asked Mr. Hawkins to meet at more public locations with cameras instead of a park. She has presented no evidence of her doing anything to help with her fear, but tell the court that she's afraid. And that is because, Your Honor, all of these issues that you have heard today in regards to the gun safe, in regards to Mr. Hawkins not providing Ms. Stewart with an inventory of the guns, in regards to the issues with the parenting time that took place on January 13, 2023, all of those instances are proper for a contempt, because they're in violation of the final judgment and decree and the subsequent documents that the parties obtained at the end of last year from their divorce decree. These are not proper for a protective order. There has been no evidence of violence on behalf of my client against Ms. Stewart shown today. She has admitted herself that these issues are in direct violation of the judgment and decree that was issued from their divorce. And therefore, the fact is that at no time has Mr. Hawkins been the aggressor, has had any type of domestic violence charges against him, or any domestic violence instances with him as the attacker. But instead, what you heard today was evidence of Ms. Stewart being the aggressor. You saw pictures of how she scratched his neck. Now, I want to be very clear for the court. When I had mentioned this incident very vaguely in my opening statements, I gave no detail, I gave no content. The only thing in which I told this court was that Ms. Stewart had physically harmed Mr. Hawkins. However, she came before you in her direct examination prior to me having the opportunity to question her about this incident, and she told you herself. She told you because she knew that it was true. Now, she also stated that she had claimed that the police told her that she could file a protective order or get some type of relief, but you heard her today in this court say that she didn't file any type of TPO or file a police report or even call the police after she erroneously claims that the police instructed her to seek some type of legal redress. She didn't do it, Your Honor, because at no point of time was she in fear of her safety. Throughout the entirety of the divorce, control has been an issue. She has tried to control the manner in which Mr. Hawkins interacts with his son, trying to control the entire situation. And her filing this TPO is just another instance, another mechanism of control in which she's trying to portray. She's trying to restrict Mr. Hawkins further from his parenting time. You heard it's been over 24 days since he's seen his son. Yet she has at no point of time called DFACS, the police, or any other third party to indicate that Mr. Hawkins is a fear, is a risk to their son's safety. And that is because, Your Honor, he is not. And therefore, we would respectfully request this court to deny the petitioner's request to have a protective order issued against Mr. Hawkins. We would request that this court deny any type of imposition of any type of penalties as a result of this action. And we would request that Ms. Stewart be responsible for Mr. Hawkins' attorney's fees as a result of this erroneous action. There has been no evidence presented that shows that Mr. Hawkins has threatened to kill Ms. Stewart, that he has threatened or posed any type of harm to their son, and therefore the grounds in which the petitioner is alleging these claims are improper. And therefore, we would just request that this court dismiss this TPO. Thank you.
Thank you. All right, Ms. Shockley.
Respectfully, Your Honor, words are evidence, testimony is evidence, and Ms. Robinson has acknowledged that there was significant testimony as to the threats to my client. And my client has been very clear in her testimony as to what those threats were, including the threat to take her life. I believe that when it comes down to words, we also have to then look at credibility and who is the credible witness. Every time that my client was asked something and there was the need to, quote, prove it up through any sort of backup document, we were able to do that. It was accurate to the extent that those documents or what have you, pictures existed. To her point, she doesn't video everything. She doesn't record every message or every interaction with her ex-husband. And she's not required to. That's simply not how she wants to live her life. Her life is already trying enough in dealing with a toddler and the constant harassment and stalking by Mr. Hawkins. I think that what we come down to, and in fact has been admitted, because they are acknowledging that he is in complete contempt of the divorce decree, is that Mr. Hawkins, he acknowledges himself, does not believe in rules. And he's in contempt. I mean, that's what they just said. He is in contempt, and he's in contempt because he doesn't think the rules apply to him. When asked, why didn't you turn over the guns like the order, required you to do it? Well, he didn't have an answer to that other than just, I guess he doesn't think the rules apply to him. He also tried to mislead this court and make them think that he had to have his guns to perform his job. That was absolutely inaccurate. And when nailed down by yourself and myself, he had to acknowledge that he doesn't have to have guns to perform his duties. And I am sorry if he likes to have guns, which is what this just seems to be about. Because we spent an awful lot of time trying to explain why we needed to keep our guns when they aren't needed for anything other than potentially harming my client. They're not needed for his job. He doesn't say that he hunts. There's no reason for him to be in possession of those weapons. With respect to the comment that my client was aware of what the circumstances were with respect to the domestic violence incident, that's correct, because Miss Robinson asked her about it, and then I redirected her So that was the reason that that came out. That wasn't because she knew what she was talking about. I mean, even if she did know that that's when he was what was being referred to, there was only one time that the police were called. But that was something that we dealt with on redirect. With respect to this concept that there are, quote, no issues with their correspondence, I would ask the court to look at the correspondence, to see where he calls her a fucking asshole, to see where she tells her you're going to pay for this, to see where he says that, this is not going to go well for you. You don't know what I'm capable of. You don't know what I will do. Where he degrades her, where he tells her that, this is all your fault. I would invite you to read those correspondence and decide whether that is interacting without issue. With respect to the exchange on the 22nd, I can assure you that my client was very nervous about that exchange. There are cameras in that park, and that is precisely one of the reasons why it was chosen. And they chose to go to a park because my client did not want it to occur in a private place. She is afraid. She has testified she is afraid. We have demonstrated that he is erratic. He is irrational. He does not believe that the rules apply to him, and he must be held accountable. He must be held accountable. He needs treatment for his temper. He needs treatment for his complete disrespect for the law, which is frankly astounding considering his background. One would think that he would respect the law, but what he does is he uses that knowledge to walk that line, and that's exactly what he's done. And he kept pointing to, well, I never said this, I never said that. No, you didn't say it in writing because you knew better than to do it. You didn't leave a mark because you knew better than to do it. And I respectfully, Your Honor, my client needs protection. Her child needs protection. We would ask that the 12-month be entered. This has gone on long enough. To the extent that she waited, we all know the statistics on that. People wait because they're afraid, and they don't want to elevate the situation. And as I stated earlier, she at night thinks to herself, if it gets entered, what happens? And if it doesn't get entered, what happens? Both of which scare her. And I think that that's all that we need to know. She knows that this is just a piece of paper, but it's better than nothing. Because when she has called on civil contempts, the police have told her there's nothing that they can do. And she has called on several different occasions, and nothing has happened. And so we need this TPO so that there can be immediate action taken. Don't think that we might not be filing a contempt as well, because obviously they've already acknowledged the contempts. And we probably need a modification of this divorce decree. But at a bare minimum, we need a 12-month protective order to keep my client safe and to allow her to return to some sort of normalcy in her life, hopefully. So we would ask that that order be entered with all of the provisions, including the removal of the firearms, including the program with the domestic violence, including the suspension of his visitation. It would be supervised until such time as at least he had completed the domestic violence portion of the order. And we would ask that he pay my attorney's fees, and I can pull up the information as to exactly what those would be for having to bring this order or this TPO when he's blatantly acknowledged that he's in violation of orders. Thank you, Your Honor.
All right. Well, it's always a shame when I have two people who are well-spoken, who apparently at one time actually liked each other. And here we are today, this being the second piece of litigation that the two of you have been involved in. The other obviously took a while. You found a way somehow to enter a consent. Court orders do have meanings for everyone, and court orders are meant to be complied with. There are ramifications for failing to abide by court orders, such as contempt, such as criminal charges, misdemeanor, and possibly felonies for aggravated stalking for any violation of a temporary protective order. Any violation of a protective order can lead to criminal charges, not just contempt in front of a judge such as myself or the divorce judge, whoever handled that. The two of you are tied together for another, well, you think it's just for another 17 and a half or 16 and a half years. Like I said, I was never good in math. It doesn't stop at 16 and a half years when this child, who I assume both of you love dearly, I don't question that, either one of you. You actually liked each other at one point. You got married, you had a child. And that child's, how that child grows up will be determined solely by the two of you. Not solely, predominantly by the two of you. I'm going to assume the child actually loves both of you. I don't think I'm getting out on a limb there. I don't think either one of you would disagree with me on that. Ma'am, would you disagree with me that his name's Harrison, correct?
Yes, sir.
Okay. Would you disagree with me that he loves his dad?
I'm sure he does.
Sir, would you agree that he loves his mother as well? Both of you are capable of raising this child to a point where he will not end up in a domestic violence court. Domestic violence is a learned behavior. The studies have all proven that. And unless you want to be dealing with getting him out of jail down the road, as loving parents sometimes do, post bond, get him out of jail, or have to deal with testifying as a witness in his domestic violence hearings, or he could become a victim of domestic violence. Because if he sees that behavior from the two people he loves the most, he will repeat it in all likelihood. The two of you, in raising this child, need to put aside your now dislike for each other. I'm going a little beyond what is normally in any orders, but I'm telling you from years of experience as a domestic practice lawyer and as a judge, time and time again, that's what happens to children who witness this. And whatever it takes, you need to stop. Keep your adult issues between the adults and do it in a proper fashion. That's why we have judges. That's why we have lawyers. That's why we have courts. And they call them civil courts, because it's a place where you can resolve your differences in a civil fashion. In an ideal world, doesn't always happen that way, as I'm sure both of your lawyers could attest. I can certainly attest to it from where I sit. But it's easy. The name calling, the blank you, all of that just compounds problems. It's gasoline on the fire. And it accomplishes nothing. Much has been made about the fact that the only evidence, well, not the only, but the predominant amount of evidence presented to the court was by the testimony of the two parties. I expected them to be in direct contradiction to one another. I would have been surprised if it had not been in contradiction to what each of them testified. It would have been helpful, obviously, for both sides to have more that they could have brought. We could have heard from the process server to rebut what we just heard a little while ago. We could have actually had the respondent's parents, or a parent, testify as to what's happened to these weapons, as to who owns these weapons. They would have had to do so under oath. I don't know. Is that why they're not here? I don't know. Are they being shielded from having to come to court and testify about these weapons? I do find that there is sufficient evidence for me to issue a 12-month protective order. It is a shame as to the ramifications of these orders, but there are consequences. And I will flat out tell you, I will enforce my orders. So both of you, there will be, the majority of it pertains to the respondent, but there are issues that will pertain to the petitioner as well, because you do have a minor child, and there will be issues that will arise, and I expect both parties to comply with each and every provision of my order. All communication regarding the child will continue by the Family Wizard app. That's the best documentation that we can have if something were to go awry down the road, where you can bring it in here. There will be no communication via telephone, via FaceTime, via internet, email, none whatsoever from the respondent to the petitioner. While the petitioner is not under a specific order restraining her from doing so, I would hope that she will get good legal advice as to the issues that may arise if she were to turn around and begin communicating. She is seeking an order that will be enforced, but that enforcement will be undermined if you violate that on your own. It's not something for which you'd be in contempt, but it would certainly impact how the court might rule down the road. As to the 2 Glocks, I want them turned over immediately. And I mean, today is Wednesday. I mean, by 5 p.m., Georgia State is not going to hold your weapons, period, or your father's weapons. The DeKalb County Sheriff is going to hold them. And they must be taken to the DeKalb County Sheriff's office at Memorial Drive by 5 o'clock tomorrow. When weapons suddenly disappear prior to these hearings, it strains the credibility or the believability for this court that they're now safe. If you went to your parents and asked for those weapons back, I don't have any doubt they'd give them back to you. The weapons that were in the picture in Exhibit G or H,
E, Your Honor, petitioner's E.
D is in David,
I believe it was E.
E. Those weapons also will be held by the DeKalb County Sheriff. You need to include them with your 2 Glocks. You had them for several years, and for them to suddenly disappear with the pendency of this order, I want them turned over. They can, if you successfully go through this program, through this 12 months without issue, you can petition the court, and when it expires, you can petition the court for the return of those weapons. But federal law does prohibit you from possessing those weapons. And I'm not concerned about Second Amendment. I'm sorry that it has ramifications as to your employment. I don't believe it has sufficient ramifications in terms of you can deal with emergency management and you can deal with IT issues with your employer. But it is what it is. And I do believe that there have been sufficient threats, sufficient intimidation, sufficient volume of unwanted and harassing communication for me to issue this order. I have no question about that whatsoever. I know the respondent does, Ms. Robinson. I know you've argued zealously for your client. but I do believe that there is ample evidence for that order to be entered. Initially, as to the visitation, it will be supervised by Nia's place in Decatur. Initially, upon completion of the 6 months of family violence intervention program, and you're going to talk to Mr. Ellis here in just a minute, or he may have, I don't know if he was on for a good period of time.
Yes, Judge, he had to step away. He said as long
Okay.
as we could get, they can put in the chat his email address and phone number.
Okay, if
In
you
the
will
chat.
do that,
Thank you, ma'am.
please send it to Ms. Robinson and to the respondent. But you need to call him by tomorrow, and he will get you set up in that program. Once that is done, if there have been no violations of my order, then your visitation, all of which is set forth in the the consent order that y'all entered, the parenting guidelines, all of which will be restored at that moment. All I need to know is that you have finished the family violence intervention program. Once that is done, then a motion is filed and comes to my attention and there have been no issues, then I will immediately restore that. The two of you have got more issues that you're going to have to deal with. Just 3 months ago, you consented to things, and now nothing's working. I know there's a lot of pressure on people when litigation. I don't know if you had a trial date, or you went to mediation. I think I heard that, and that's pretty much the last step before you actually get to court and try your case. And I know that decisions are sometimes made under pressure. If you feel there's something that's not working there, you can move to modify it. If you feel the other party has been in contempt, y'all can just litigate till the cows come home, as they say, and pay attorneys lots of money. No offense, Ms. Shockley and Ms. Robinson, but it's expensive when two people can't work it out. I gave the opportunity for y'all to do that before hearing the case today. I don't know what all the stumbling blocks were as to the insistence to go forward. I don't know who or whether both of you. No, let's go forward. But you had the opportunity, and I'm glad that your attorneys worked very hard with you to try and get that resolved. They're both good, experienced attorneys, and they knew that once you got in here in front of me, you're letting a third party decide things that's decided on your own. But it didn't work that way. So for now, you're going to have to live with this order. And I will issue the order that will be sent out. Nothing else in your divorce changes. I'm going to deny both sides, obviously, the attorney fee issue. That's going to have to be, you got a lot more to go. But I'm not going to grant attorney's fees to either side in this case. Is there anything either party knows of or has questions about before I let you go? I'm sorry, either counsel, not the parties. I'm not speaking with anybody but counsel at this moment as far as anything that
Not
I've left out.
Not for me, Your Honor. Thank you.
No, Your Honor, and I have communicated with the clerk to provide Mr. Hawkins information.
Okay. All right. All right. Good luck to both of you. I hope that both of you will do what's right for Harrison. If I tell you what, I'm gonna change something here that I've already said I was gonna do. I'm gonna change it part way. I'm gonna change it to 3 months of involvement with the family violence intervention program. And then I will change it to where the exchange of visitation takes place at Nia's place. Until then, it'll be supervised visitation. After that, after completing and verification through Mr. Ellis that you have been attending the program as required, once you've done 3 months of that, then I will go ahead and, reduce it to the 3 months. You can restore all the regular visitation with the exception of the exchange at Nia's place. Now, let me tell you, with Nia's place, they call it orientation, but basically you have to contact them. And the quicker you contact them and do minimal paperwork with them, the quicker all of this is going to get started. If you drag your feet, and I'm going to speak to the petitioner who has sole custody, I want you to get this done ASAP. Okay? As soon as possible, you contact Nia's place in Decatur. Ms. Goodman or Ms. Broom or Ms. George, can you give them the number via a chat? Anyone there?
Yeah,
Okay,
I could send it in the chat.
okay. Because the quicker, I'm sorry. The quicker you do this, the quicker contact can be reestablished. Now, let me ask, in the divorce decree, was FaceTime a part of that consent?
I believe it was, Your Honor. I'm speaking just out of pure memory. I believe it was.
Okay, that too is suspended until the 3 months. Okay, after that, then everything that's in your original consent can be restored. If you modify it between now and then, that's fine. We'll go with whatever that may be. But until then, there needs to be a buffer here. And this is a Band-Aid until you can get things resolved in terms of any modification that you wish to file in your divorce, or contempts or whatever. Ms. Shackley, you have something?
I did have a question, actually. Certainly, I understand that Nia's place is good because it provides the supervision. It is somewhat of a distance for my client, and I believe for Mr. Hawkins as well. If they wanted to, once we finished with the supervision period, if they wanted to do the exchanges at, say, the police station or fire station or something like that, would that be?
I do not do police stations. I'll tell you that. I don't like it. It's traumatic to kids to have police. No offense to you, sir, as far as being a police officer, but it's traumatic to kids to be around a bunch of police just to go from one parent to the next.
Okay, I understand your own.
But I have done, and when you say some distance, I mean, both are ITP. Everybody's inside the perimeter, and Decatur is not, in the next state or next county. So it's probably 10 miles at most.
I honestly don't know, Your Honor.
I'm just guessing, but
I would have to guess too. I live in Brookhaven near them, so I know the general length and that it would take a while.
Okay.
That's why I bring it up.
It may be more traffic than distance as far as the
I think
issue there. I mean, there's traffic getting to Brookhaven and getting to around Perimeter Mall. I mean, that's
Absolutely right.
You live in Atlanta, you deal with traffic. Comes with the territory. But all right, is there anything else?
I would like to clear up one issue. We're obviously going to get right on this as far as our obligation with respect to Nia's place, and I don't really know exactly what that is, Your Honor. Is that when you send out the order that I will need to go ahead and forward it to them?
Yeah, I have one more hearing coming back in to hopefully finish up this afternoon, and then I will be transmitting orders to the clerk's office later this afternoon, early evening, or first thing in the morning, and then they will in turn transmit the order to the petitioner side. Ms. Robinson, you may have to request a copy from the clerk's office or get it from Odyssey, as far as logging on that way. But yes, I would hope that the petitioner could make contact with Nia's place by Friday.
Okay, Your Honor, I have one more concern.
And that's a very limited visitation, I'll tell you. But The incentive is that let's get through these 3 months and get visitation restored.
I understand, Your Honor.
I'm sorry, sir, but that's the way it is. That's the way I found it. Go ahead, Ms. Shockley.
I just had one question, and that is that this weekend would technically be his weekend. And
Not gonna happen.
Okay.
Okay. All visitation for the roughly, it's gonna probably actually be a tad more than the 3 months, because the quicker unless you can get in with Mr. Ellis very quickly, get that going so that you can start counting your 3 months worth of FVIP program. And also getting Nia's place set up. But visitation is suspended otherwise until that time.
thank you, Your Honor, for the clarification.
All right, that concludes the hearing.
Thank you.
And just,
Oh,
has your clerk forwarded, I know, I'm sorry, has the clerk
sorry.
forwarded the phone number for Neil's place? I don't believe I've received it yet. That's just my last thing.
Okay.
I sent it to the petitioner's attorney,
Oh,
Okay.
okay,
and
that's
he
fine.
ordered the
Okay.
petitioner
Ms. Shockley, if
to,
you would forward it to Ms. Robinson, that would be great.
but I can send it to you.
I know y'all have worked hard together trying to get this resolved, so hopefully we can work hard and get it concluded in the best interest of Harrison. All right. Everyone's free to go.
Thank you, Your Honor.
Just give me 1 second so I could,
Okay.
send a chat to the attorney before everyone leaves. And just